Court of Appeals, Texas is now in session.
Please be seated. Good morning. The next case on our docket is cause number 7-23-00209-CV, Jeremy Scott Nelson versus City of Lubbock. Each party will have 20 minutes for argument. The appellant will have a 5-minute rebuttal. Who will be arguing for appellant?
Max Smith on behalf of Jeremy Nelson.
All right, Mr. Smith, and on behalf of the city.
Brian Brook for the City of Lubbock.
Thank you. Yours?
Your Honor. May it please the court, counsel. My name is Max Smith. As I said, I'm here on behalf of Jeremy Nelson on the case before the court today. Mr. Nelson was a homeless individual who resided in Lubbock at the time of this case. I'll give a little brief factual overview. The relevant facts happened in February of 2020, just before the sunrise, on a day where it was kind of cool, prior to kind of a flash freeze, as we all know can happen in this area in January and February in the winter. Mr. Nelson took shelter behind a dumpster in an alleyway in the city of Lubbock, and a city garbage truck came down the alleyway and rode over both of his ankles and feet on his foot of one leg and ankle and foot of the other, resulting in severe injuries. Procedurally, Mr. Nelson filed a suit, and the city filed a no evidence and a traditional motion for summary judgment, as well as a plea to the jurisdiction, all of which were granted, and that brings us to this appeal here today. Now, there are three main points before the court today. It's going to be whether or not the waiver of immunity under Texas Tort Claims Act 101.021 applies in this case as it pertains to the negligent use of motor-driven vehicles, as well as whether or not Mr. Nelson was engaged in recreational use under Chapter 75 of the Texas Civil Practice and Remedies Code. Mr. Nelson would state that the motor vehicle waiver of immunity does apply, and that he was not engaged in recreational use. And then further, the court is going to have to determine whether or not there are factual disputes that would preclude the summary judgments, and that would be needed to be addressed by a jury. And whether or not, but before that, the court's going to have to determine whether or not the driver had a duty to exercise reasonable care upon observing the abnormal conditions and visible debris in the alleyway. And it's going to be somewhat, the facts of the matter the facts of the case are going to matter, because the reasonable care that needed to be taken in this particular situation is a little bit different than what may have needed to be taken normally by a driver under normal circumstances.
Let's begin there, because what a reasonable driver should do under the circumstances tends to go to what a reasonable driver, whether a reasonable driver owes a duty or not. My understanding of what your argument is on appeal is that drivers who are driving down an alleyway or another, I guess an alleyway is defined as a street under Texas law, that drivers have an obligation to somebody who may be inside the debris to avoid the debris. Is that your characterization of how the duty is defined here?
Generally, I would state that the driver for the city's duty is a little bit different, seeing as that he is a CDL driver operating a $50,000 garbage truck for the city, and his job is to pick up the garbage. And in this particular case, he actually drove over the garbage.
Right, but how would that change what the duty is?
So it's going to be Mr. Nelson's contention that if there is something on the ground that is large enough for a person to be under, that a driver has a duty to not drive over that, or to investigate. In this particular case, he probably had a heightened duty to investigate it because of the relationship between his job and what it was. to just take another example, if there had been a child playing hide and go seek in the debris, this would be a totally different thing, but the duty would be the same.
And I'm familiar with cases where a driver obviously owes a duty to other drivers. You're driving down, you run over debris and it kicks up and hits somebody else. Maybe there's a duty there. I don't know that I've seen a case that covers that. But what we're talking instead, not is driver to driver, that duty, but an extension of Texas law to say that you owe a duty to actually inspect the debris to see if something's inside the debris.
In this specific case, we're talking about a CDL driver who's operating his vehicle in very close proximity to these residences. As I don't know if y'all are familiar with Lubbock, but they do operate there. They operate city alleyways where the garbage trucks are. Now, this is not a premises liability case. This is a car wreck. This is a motor vehicle case. But we're in very close proximity to these people's houses. The alertness of a driver in that alleyway has got to be different than it is on a regular road. It's a one-way street.
Where do we draw the line there? Do we say that drivers have a duty to check underneath their cars in the morning to make sure nobody's underneath the car?
I've thought about that. I would say no. A driver does have a duty to kind of inspect. A CDL driver certainly does have a duty to inspect their vehicle every time they take the vehicle out. A regular driver, I would say that you have a duty to at least give a casual glance. Now, if you're in your garage, it's totally different. If you're on your front driveway, you may have more of an obligation to at least be alert what's going on around you.
The Supreme Court, numerous times, I guess, going back probably 20 years or so, at least, well, maybe even since Payne, since the 90s, has talked about how we define duty, and that we look at a risk utility set of factors. One of the issues involves foreseeability. Is there any evidence in the record? Maybe there was evidence in the record that Mr. Martinez is aware that there are other individuals that are homeless who live in the area. So is there any evidence that Mr. Martinez has ever encountered other individuals living in the debris in an alleyway?
In this particular case, I don't know that there was any evidence that Mr. Martinez did. Now, he was about 21 years old or so at the time, and he was very new. I do believe that he should have been taught on that a little more, and I don't believe that his inexperience, the city cannot be held liable for the lack of training in this case, but his inexperience is not an excuse. Now, to go back to what you just said, there's a in the state's brief on page 13, there's a balancing test. They state to determine it. There's a case that states to determine whether a duty exists. And I think you know this. We weigh the risk, foreseeability, the likelihood of injury, and the consequence of placing the burden on the defendant. And that is, some of those are more specific than others, right? So the foreseeability is one that in my opinion, if something is large enough for a person to be under, it should be foreseeable for a professional driver to say maybe we should to be a little bit more careful.
What would the consequences be of putting the burden on the defendant versus putting the burden on the plaintiff to avoid vehicles that are driving down an alley?
So I believe the analysis is strictly related to the plaintiff, but in this particular case, the burden is nothing because his job is to pick the trash up, and that's not what he's doing. I understand on a regular person driving down the highway, that's different. But his job is to pick the trash up, and there's no burden whatsoever on asking him to go pick the trash up rather than drive over it.
So are you saying the duty here should be hypothetically, if I'm going down an alley, there's an Amazon cardboard box that could hold a child. So the duty is to stop and get out and inspect the cardboard box.
I believe every person's dad, when they were learning to drive, he told them not to drive over things. And mostly that's to not destroy your car, but originally it was probably not to drive over someone that might be in the box. That's what I think. I think if it's large enough to hold, and I'd rather on it a pet, like if it's something that might hold a pet, maybe we don't have a duty for that. But if it's something that could hold a child that would be old enough to run out of the backyard in an alleyway, if we're driving down the street, it may be different. But in an alleyway, I mean, kids play in alleyways, people are in alleyways, the conditions of it being 20 degrees. I mean, there's the exigence of the circumstance, the fact that he was supposed to be there picking the trash up, the fact that the nature of the risk was so high, there are factors that we have to consider. It's not just, I'm not driving a Honda Civic down the alleyway or driving a $50,000 or 50,000 pound garbage truck. So the risk is higher. The likelihood of injury is absolute. if you run over somebody.
If we look at burdens, I mean, certainly we know from the evidence that that it was cold that day. I mean, that's your client's position that because of the imminent poor weather conditions in the area, he needed to take cover. If we adopt your position on a legal duty, though, it would put that obligation on Mr. Martinez to get out of his truck and to go undergo those conditions in order to make sure that the trash doesn't have somebody inside of it.
Just as it pertains to his duty, the jury can come back and say Mr. Nelson was unreasonable. Nobody's saying that they can't do that, but Mr. Nelson deserves to have his day in court under the law. I do believe that there is a duty that should be held on the CDL driver in under the specific circumstances of this case. And there's nothing on, I mean, I read the respondent's brief. I didn't see that they found anything directly on point. If there was something directly on point, it'd be an easy deal. But I think that the specifics of this case warrant a little bit of a heightened duty over what you would normally expect. Now, I do think that's the difficult question here. It gets even harder if the court determines that the recreational use statute applies. Under the law, the recreational use statute does not apply. Under Texas Civil Practice and Remedy Code, Chapter 75, the recreational use statute wouldn't wipe the case out. It would just create it. It would just bring it to a gross negligence standard.
Was gross negligence pled?
No, but I don't believe it has to be pled. It's just that's the standard under when we go to court, that will be the jury charge that we put to the jury. I don't believe that it's required that it be pled in the actual pleadings.
How could a jury get a charge to include a gross negligence instruction if it's not included in the pleadings?
Well, so that the defense would ask for it. I mean, the defense would bring Chapter 75. They'd state that it's recreational use. The judge would make a decision of whether or not it is, and then would just give the jury the higher burden as opposed to the standard burden.
Would the jury then be charged? I guess I'm trying to figure that out. Is that limited just to the defense instruction, or do you then get to go ask for exemplary damages if a jury says yes?
No, but I don't believe they're pled either, and I don't think we could get them either way. I think it's just I think it just changes the goalpost. I don't think it changes anything else.
Would it require a unanimous verdict that you would typically have to have in a gross negligence case?
I don't think so. I think it would be the same. It just changes the questions. I think everything, I haven't looked into this, but I don't think it would be, I think it would be the same. I think it would just only change how much weight we have to put on the scale. It doesn't change anything else.
Have you cited to any authority that suggests that you don't have to plead gross negligence?
I have not. I don't believe that it was recreational use, and I'll run through that real quick. They're relying that it's recreational use. The statute says the word recreational use. We're going to say the word recreational use a lot, and everybody knows what that means. It means a leisure activity that you're doing for fun. It doesn't mean hiding from the cold. There's evidence in the record that says that part of what Mr. Nelson does to support himself is he salvages garbage, and that's what he was about to do. And so he's either on the way to work or he's taking cover from the cold. He's not, at the national park camping. I expect that the city's going to point to a penal code statute or I think it's a penal code statute that defines camping, but the recreational use statute does not direct us to the penal code. There are many, many statutes that do direct to other statutes for definitions. This one does not. If the legislature wanted to direct us to that definition, they would have. They're saying it's recreational use. We just use our common sense on what is recreational use. The recreational use statute isn't designed to bar people from suing the government. It's actually designed to give people the opportunity to make a claim against the government only at a higher standard. And so I don't believe that it's recreational use under the plain language of what that word means. It's not defined in there. I don't believe that we should be able to use the penal code definition.
I want to clarify something. You keep saying plain language. Are you talking about the title of the act, like the statute, the recreational use statute, or are you just talking about camping?
Both. Well, so I'm talking about, I'm talking about both. But the word camping is underneath the title, which is recreational use. So we must make the assumption that all of these things are in the recreational capacity, not in the, we're gonna we're in the war and we got to make camp.
Right, so the recreational use statute delineates lots of different things that count as recreational use: camping, skiing, boating, watching radio controlled
Yes.
airplane shows. How should we define camping? The
It's-
legislature didn't define it. I think the city has pointed to the penal code to say, hey, use this penal code as a definition for camping. How should we define camping?
Camping is a leisure activity that people partake on. They go to parks, they go to campgrounds, they go to hunting, and they may camp as opposed to hunting. They may go to a children's camp that's overnight camping. The key point is that it's got to be recreational and not out of exigent circumstances or necessity. It just doesn't say that. It just says recreation. It doesn't say anything about
Hypothetically, what about a homeless person camping at a park?
if he has no home, then it's not recreation. If that's, I'm not saying they should be doing that, and I'm not saying that they shouldn't be cited for it. But under this statute, it does not say it's referring to recreation only. Now, if the homeless individual lives at the night shelter and he goes to the park with his buddies and he stays there overnight, that might be camping. But if he is staying there, and that's where he's not even staying there in this case. I mean, he's only there. The evidence is that he didn't even intend to fall asleep and that he was going to start working the second that the cold blew through.
Under the penal code definition, the intent is important. And what evidence of intent?
He did not even intend to fall asleep. In this deposition, he clearly testified that he did not intend to fall asleep and that he knew that it was dangerous to be there, but that he had no other choice and that he had to be there.
I thought there was evidence in the record that he did enjoy sleeping outside. In fact, he left the hospital or something because he wanted to go outside.
He does. He likes being outside, but what he's also testified to in his deposition is that he does not stay where people can't see him when he's going to go to sleep, because people get scared when you surprise them and you don't know what they're going to do. And that's the undisputed testimony. I mean, there's no counter testimony to that. He said that he would have rather slept in someone's yard than in the alleyway, but there's further testimony that he's known numerous people that have died in these flash freezes, and that you have to take shelter or it's a perilous situation. And all of this is all, well, this is camping. We're talking about camping. A lot of this is kind of like factually weighed stuff, contributory negligence stuff that the jury will consider. And
So this is really with regard to the summary judgment and not the plea to the jurisdiction.
the recreational use would have been, I don't even know if the judge specifically ruled on the recreational use issue. It would have probably been in the summary judgment, not the plea to the jurisdiction.
So are you saying there's a fact issue?
I think that y'all have to make the decision on what is camping, but whether or not it was negligent for him to be there is a question for the jury.
Does the location matter in your analysis for recreational use? So from what I'm understanding, you're arguing it's whether or not he was actually seeking this out for leisure or fun or something. But does the location that it's in an alley affect any of the analysis?
I don't think so. Yeah. But there's no counter testimony, or there's no evidence other than the fact that it was cold and he was taking shelter and that he didn't want to sleep there, but he was just exhausted, so he fell asleep. And I'm not saying that he should have been there, but that's a fact issue.
So if hypothetically speaking, if there was somebody who wanted to camp in an alley, I'm gonna go set up my tent in the alley, that could be camping under the recreational use statute.
If it was for recreation. So if a homeless person goes and camps in the park argument, if the homeless person lives at the homeless shelter and he's like, I'm gonna go do recreation in an alley, potentially. But there's so much evidence that that's not what was happening here. He was going to work in the area to salvage, and he did not want to go to sleep. And this flash freeze, there's just no other evidence of anything else. That's all we have to go on.
Are you aware of any cases under the recreational use statute where the courts have said we look to the plaintiff's subjective intent on whether they intended to enjoy the experience or not for purposes of determining whether their activity falls under Chapter 75?
I don't have anything specific. There's cases that are kind of few and far between. There are a lot of them, but there's issues that are all over the place. But But just the term recreational use, if I might pull the I don't, to answer your question.
Well, I mean, would you agree with me that the statute can, I mean, the legislature can define recreation however they want to define recreation?
But they didn't. They just said recreation, so we got to do it.
Well, they said recreation means an activity such as, and then gives a laundry list of A through Q, and camping's on the list.
Let's see here. I mean, it's just,
Yeah.
yeah.
Let's do it this way. Let's compare what the legislature did in chapter 75 of the Civil Practice and Remedies Code versus what they did under section 48.05 of the Penal Code. I understand your argument to say you shouldn't consider how camping is defined. But under 48.05, the legislature did make a distinction between types of camping. Did it not?
It does in the penal code, but that's for
My point is this: the legislature could make a distinction between whether you're camping for enjoyment or camping for survival if it chose to do so under 75. What do we take from the silence of the legislature in not making that distinction?
that it doesn't say anything about your survival or necessity. If it said that, then it would say that. But in the case it doesn't. And there's just no facts that even. There's an argument from the city that states that he's camping, but there are no facts that state that he's camping. He's just a person that was exhausted and ended up where he was. And that's not recreation. And if I might have like 30 seconds to cover the Texas Tort Claim Act, I'm at the end of my time.
Yeah, you're at the end of your time. Can you save that for your rebuttal?
I can. Thank you.
Thank you. Mr. Brooke.
May it please the court, counsel. I will jump right into where the court began with Mr. Smith as far as the duty that's owed to a particular individual, whatever duty a driver owes. And I'll remind the court, and I think the court's well aware that the legal duty is a question of law that's appropriately addressed by the court. And in doing so, the court has its analysis where it weighs the risk, the foreseeability, the likelihood of injury, and the consequence of placing the burden of a duty onto a particular defendant. And this court has held in Flores v. Rector in 2020. I don't believe it's in our brief. The site for that's 2020 Texas App Lexus 6735. That foreseeability is the foremost and dominant consideration. In this particular case,
Was that for purposes of defining a legal duty, or was that for purposes of just understanding negligence under the elements of
for
negligence?
finding a legal duty. In this particular case, and I think Mr. Smith goes as far as to say, or the appellant acknowledges, that there is no evidence that Mr. Martinez would have ever known or foreseen that a homeless person would have been sleeping underneath the debris covered up in this particular case. There's no evidence, there's no testimony that he had ever witnessed it before. In fact, the evidence is to the contrary, that he was very familiar with this particular area. He had driven this route many times. He knew that it was constantly littered with debris. In fact, had, to his recollection, called it in 4 times for excessive debris. So this was nothing unusual to him to see this debris.
Is the foreseeability test a subjective one or objective? I mean, does it matter if it?
Well, I think to apply it to all drivers, you would have to look at it objectively, not to a particular individual.
Right. So why do we care if this particular garbage truck driver had seen this before or not?
Well, it just goes to the weight of what his expectations were, whether or not he would expect to see somebody, again, buried under the trash seeking shelter. Another issue that was brought up that I think the city's position is actually the opposite that Justice Doss brought up is the burden that this would actually place on a driver to get out and inspect every pile of trash that somebody could potentially be under. That would be a huge burden to place on drivers to get out and inspect any piece of trash that somebody or something could potentially be under. In this particular case, if it was applied, it would require our solid waste drivers to get out, inspect every piece of trash, get back in, then pick up the dumpster and proceed on. If that were the case, the city would never get the trash picked up and the city of Lubbock would be overrun with trash.
So the drivers, as a part of their training, they're not instructed to avoid debris?
They are instructed to avoid debris when possible, and that's primarily for the preservation of the vehicle itself, to not run over things that would tear up the undercarriage of your vehicle, pop your tires. We want to be able to keep the trash trucks on the road and in the alleys. But in this particular case, and the pictures have been submitted with the record, I think even referenced in the appellant's brief, you can see there wasn't a way that this trash was going to get picked up without running over the edge of the debris. The pile of debris fell out into the part of the alley in the right of way that was necessary to drive over in order to pick up the dumpster.
That seems to be more of a fact-based question though, because piles of debris can present differently depending on what alley you would drive down, right? I mean, we can't say as a matter of law, a pile of debris of X size does not create a duty, but maybe one larger does. I guess we could, but my point is, I think that's something that a fact finder would assess if they consider that to be relevant or not, right? How big can a trash pile be before you have to look?
Yeah, I don't know that it's a question of fact sort of appropriately submitted to the jury. That's still, whether a duty exists is still properly presented to a court. So a court can make that determination, determine that a 5x5 pile of trash, well, you do have a duty in that particular case.
Yeah, but following up on this, what you just said was there was no way this trash was getting picked up without running over it. That's not necessarily true. As soon as he turns down the alley and he sees that he's going to have to run over something, he could have gotten out and moved the debris.
He could have.
But I guess your argument is the legal question here is, should he have to do that?
Yes, and should he have a duty imposed on him to do so?
Can you, asking questions about that I asked to opposing counsel just a minute ago, could you see possible foreseeable harm caused by driving over debris in an alleyway?
Sure. I mean, there is some amount of risk. To say there would be none would be, I mean, that wouldn't be an accurate statement for me to stand here and say there's no risk in ever running over any debris. However, that risk is significantly lower in an area and that has kind of a habitual problem of having a bunch of debris in the road. This particular driver had driven this course before, seen it before, had run it over before, and nothing had ever happened until this day in February 2020.
The same debris?
I don't know that if it's in the record that it was the same debris each week or different debris or.
Understood.
I don't think that that's in the record. Only that at least 4 times he had called this in because it was so excessive in this particular area.
Let me ask
And
you,
that didn't put him on a heightened awareness that since he knew based on his.
I would
previous
argue the
experience.
opposite, or say that it would be the opposite, that he's seen it a bunch of times and he's never seen a homeless person sleeping under it. There's no evidence he's ever seen this particular set of circumstances. So the likelihood of injury is low, the foreseeability is low, And again, the burden that it puts on a driver to have to get out and look under any amount of debris that something child size or otherwise could be under, that's an undue burden.
The city filed a plea to the jurisdiction and a motion for summary judgment. Is that right? Those
And
were
no
indi-
evidence motion for
And
summary
a no
judgment,
evidence
correct.
motion. Those were independent motions.
The
Plea
two
and
su-
motion.
The two summary judgment, the summary judgment and no evidence summary judgment was one, and the plea to the jurisdiction was the other.
I know you've spent a lot of time talking about the summary judgment aspect of the case. Before we're able to reach the summary judgment issues in the case, don't we have to first address whether your client is immune under the recreational use statute? Or is there a way that can be shortcutted and included as part of a single analysis?
I think they just have to be taken up together because unfortunately the trial court in this particular case granted them all together. And so instead of granting the summary judgment and not the plea or vice versa,
Well, there's two separate orders.
correct,
Right.
but at the same time,
If the trial court grants the plea to the jurisdiction, then how can it grant a summary judgment if it doesn't have jurisdiction?
that is a great question for Judge Hatch.
In fact, if the court said it doesn't have jurisdiction, the dismissal would have to be without prejudice, right?
Correct,
You wouldn't have a summary judgment.
correct. The city presents both and hope to get either one granted. In this particular case, both were granted. So if we want to move just to the recreational use and take the position that if the plea to the jurisdiction was granted under the recreational use, then we shouldn't even be on appeal on the summary judgment because there was no jurisdiction or authority for the court to issue an order on summary judgment. We're happy to oblige in that course.
Let's look at the definition, the penal code's definition of camping.
Okay.
Section 48.05 defines camping as residing temporarily in a place with shelter. And my understanding from what Mr. Nelson is arguing is that there is a difference between camping for recreational purposes and for camping for survival purposes, for lack of a better description. Here's why I'm asking you the question. If you look at 48.05 D1, the legislature appears to make that distinction when it's talking about consent on public lands. It appears that the legislature is saying that the governmental entity can't provide consent if it comes to camping for other purposes, but it can provide consent when the camping is for recreational purposes. That seems to fall consistent with what the appellant is saying, which is maybe the legislature does intend a distinction between recreational purpose camping and other camping.
For the purposes of the penal code, I would not disagree, but we have to look at it under under 75 of the Civil Practice and Remedy Code, under the recreational use statute, which the case law is well established under on recreational use, and that is that intent does not matter. It is the activity at the time of the injury.
I understand that, but if you're relying on the definition of camping under 48.05, don't we have to read the statute in toto to make sure that the definition is provided within context?
No, I don't believe so.
Well, I'll follow up on Justice Doss's question. So the legislature did not define camping for the recreational use statute. In your briefing, you are asking us to look at the penal code to define camping.
Correct.
Okay, are we not supposed to read the entire section to define camping? Or, I mean, how would you have us define camping?
I would do it either under the penal code section. And in this case, if you apply the penal code section, you could say, well, there's not an exception for, or there is an exception potentially for recreation, but the facts in this particular case are this wasn't any type of authorized camping for the purpose of recreation. It was unauthorized camping. And then you, at the same time, you just So you're looking at it just for the definition of camping. So it is camping. And then you go back and I think you still apply the recreational use separately. It's not controlling that the definition has a carve out for allowable recreational use in the penal code and when applying it under the recreational use statute.
Yeah, I'm gonna butcher Mr. Nelson's argument, but just to sum it up, I think his definition is like sleeping outside for fun is camping, sleeping outside for necessity is not. You're saying he was sleeping outside for fun?
No, I'm saying he was sleeping outside for necessity, and under the recreational use, intent doesn't matter. The thing you look at is the activity itself. So even if you don't want to use the penal code, if you want to do like UTA versus Williams and just apply a general Webster's dictionary definition of camping, you could say it's to make camp or occupy camp. And these are Merriam-Webster definitions of camping. To live temporarily in a camp or outdoors, to take up one's quarters, to take up one's position or settle down. That's exactly what Mr. Nelson did in this particular case. It was getting cold. He was looking for a place to stave off the frost, the sudden frost that was coming. He found a location, laid down on some carpet, covered himself up with a blanket amongst the debris in order for shelter. Nothing in the definition says it needs to be for fun. And that's not what the case law says. The case law, again, on recreational use says intent is, not an element when looking at the activity. Like in the city of Plano.
Should we look at legislative history at all when trying to define camping? When, the legislative history of recreational use is the purpose of the statute is essentially to allow people to come on to enjoy lands. You go camping in a state park or you go camping at a lake. This is in an alley. Should we look at that when trying to define camping?
Well, I think that the legislature and their constant expanding of it, and UTA versus Williams does a good job of going through the lineage and the legislative history of the recreational use. Although, as you properly cited in your dissent in Rodriguez, Justice Charbonneau, that is a plurality. It's not necessarily controlling on this court, but it states in Williams and mentions that although that was the intended purpose, and again, originally the recreational use statute when it was enacted was only granting those rights to private landowners. It was further expanded to include additional activities. Then it was expanded to include governmental entities as getting the protection under the recreational use statute.
Let me stop you for just a minute because I want to focus on the text of what 75 says in regarding your response to Justice Yarbrough's question. Under 75.01 sub 3, it defines recreation. And like I said, we talked about camping as being included, but look at subsection L under that 3L. Any other activity associated with enjoying nature or the outdoors. The legislature could have said any activity associated with enjoying the outdoors. And I would agree with you that maybe camping could be done for any purpose. The fact that the legislature used the word any other activity suggests that maybe the preceding list of things are examples of what the legislature includes with or consists with enjoying nature or the outdoors. Can we read 75.01.3 definition of recreation? If we read it in toto, do we have to include that language as part of our discussion?
No, that's not how the courts have applied the enumerated list. The courts have explicitly said if you're doing one of the enumerated activities, whether it be for pleasure or not, or enjoying the outdoors or not.
What do we do with the word other then?
I'd say that's similar to Belmead Torres, right? Where the individual was outdoors, was about to play softball or baseball, and was enjoying a park swing. So that falls in the category. Again, that's for things that are not enumerated within the list, within the definition of recreation.
But
in that particular case, swinging, enjoying the swing set is not a listed activity. So it is an other activity associated with being in natures and outdoors.
So your point is that the language with enjoying nature of the outdoors is specific to L and it is not intended to be included as a part of the rest of the enumerated list up to that point of A through K.
That's correct. I mean, that's what the case law shows too, whether it's City of Plano v. Nelson and the gentleman that was bicycling, and when the city of Plano injured him, he was not doing it for enjoying nature. He was doing it because it was his only means of transportation, and he got hit by a car. I believe the Peralta case was similar to that, and then even recently the Lubbock County Water Control District case. This court recognized that you look at the activity at the time of the injury, and in this particular case, Mr. Nelson was camping at the time of the injury. So it doesn't matter whether or not.
Sleeping. That make a difference? He was sleeping.
But yes, you can be sleeping and camping at the same time. I mean, those aren't
Not mutually exclusive.
correct.
Do we have a fact question here on whether it was camping? There's evidence in the record from Mr. Nelson's testimony that he was trying to get away from the elements, and I think his phrase is that he conked out. Does that, maybe a jury ultimately says, yeah, we think he was camping, but is that a question for a jury to decide if we have to draw the evidence in favor of the non-moving party?
No, that's a question of law properly submitted to the court for the court to decide whether or not the person was doing one of the activities.
What's your support for that? Because I think under Texas Department of Transportation against Miranda, the court says that there are some times when there's a jurisdictional challenge that's brought and we can't make the determination as a matter of law, then we basically treat it like in the same way that we would treat a motion for summary judgment. And that seems like that would be drawn in favor of the non-moving.
Well, I mean, this is a review de novo looked in favor of the non-movement. That's not disputed here, and the city's not disputing that. However, there's not a fact issue as to what actions Mr. Nelson was taking at this particular on this particular incident. The only question is, was it camping or not? Again, the facts are undisputed, so there is no fact issue. So the matter is properly addressed by the court. I can give a summary if you like, but my time is up.
Further question?
I don't have anything.
You.
Thank you.
Yes, ma'am. May it please the court? The first thing I'd like to address is the City of Plano case appears to be a case out of the Dallas Court of Appeals. Not all Court of Appeals are right all the time, and I would posit to the court that that gentleman that was riding his bike for transportation was not conducting a recreational activity, and that y'all can make your determination the way that you see fit rather than the way that the Dallas court did.
What was the writ history on that case, if you recall? It was petition denied or? If you don't know, it's okay.
Petition denied.
Okay. So the Supreme Court had an opportunity to take it up if it chose to do so.
And they did not. It's still not, I would say that it's not binding on this court. And the facts here are just a lot different. He was absolutely riding a bicycle in that case. In our case, he was taking shelter. He didn't mean to fall asleep. He was about to start working. There's a lot of things. What I want to go back to, that was a point that one of y'all raised just a minute ago, which is that if there was if the plea to the jurisdiction on the Texas Tort Claim Act, on the 101021 Texas Tort Claim Act was granted, then there was no, the court had no subject matter jurisdiction to grant the summary judgment. And with no subject matter jurisdiction to grant the summary judgment, which can be challenged at any time, whether it was challenged or not, none of those issues are even relevant here today. And the court was wrong to grant the plea. So the plea to the jurisdiction is only on 101.021. The recreational use is not a jurisdictional issue. That's a summary judgment issue as to whether or not it was recreational use, and the burden changes. That's a summary judgment issue. So the plea to jurisdiction,
Is that not a jurisdictional issue? Because the city is contending that it's it's protected under the Tort Claims Act because of the recreational use statute.
so the recreational use is under chapter 75 of the Civil Practice and Remedies Code, and it's not under there's another argument that they made under 101.0215 that talked about whether or not it was there's three things. There's about whether or not a municipality is liable for damages under governmental functions. Now that is the plea of the jurisdiction issue. Real quickly, I'm going to go through 101.021. The chapter states that a governmental unit, I'm going to paraphrase here, that a governmental unit in the state is liable for personal injury caused by a wrongful act or omission of negligence or the negligence of an employee acting within the scope of employment if the personal injury arises from the operation or use of a motor vehicle, which we have here, or motor driven equipment if he was stopped or something. There's no argument to say he was doing something else.
So on the plea to the jurisdiction, if the recreational use statute applies, that increases the burden to a gross negligence standard. I don't think the waiver in 021 would apply to a gross negligence claim. So that's why there would be no jurisdiction if the recreational use statute applies.
Yes, so the recreational use statute is gonna, even if I get the argument under 021, even if the waiver exists, they can still argue recreational use. But it's not a jurisdictional issue. The court doesn't
Saying it's a
lose,
summary judgment.
yeah, the court doesn't lose jurisdiction just because it was recreational use. But the court does lose jurisdiction the second they grant this plea to the jurisdiction on 101.021, which was done incorrectly. I mean, he was absolutely using a motor vehicle. If it had been a private person, we could have at least gone to trial on negligence. It was caused by a condition of tangible personal property. It's a little confusing the way it's written. Basically says the same thing twice, that the person would have been liable under negligence. Sorry, I'm going fast here. Then 101.0215, they're trying to argue that taking out the garbage is a governmental function, and that they should not be liable under that statute. But 101.0215 actually says that they are liable under this chapter for damages arising from governmental functions, i.e. garbage collection. So we're going under the chapter, and the chapter under 101.021 says that it's waived. And so it is waived. The question then becomes all of this other stuff. And I wanted to just say one thing about the burden, about the duty. We talked about teaching kids to drive, and in the prior case, we talked about the judges just simply reading the admonishments to the person. If we would just do all of the things, we can't gradually lessen the burden and lessen the burden and lessen the burden. If the drivers got out and picked up the trash in the alleyways, they'd go back and complain, and the alleyways would be clean. There wouldn't be trash in the alleyways. And so the idea that we're going to create this overwhelming burden on them by lessening the duty, just as a matter of public policy, I think we're going in the wrong direction when we're doing things like that. And I think we do it more and more. But I'll close with that. And I'll thank y'all for your time.
Thank you. The case is submitted. We appreciate you coming here to Amarillo today. And if you have time and want to stay for our bar luncheon, that'll be meeting at noon downstairs. And then the court has an open house beginning at 1:15. We'd love to have you.